Hello and welcome. There's now no more ambiguity about local government autonomy and how it should operate in Nigeria. Now, this is after the landmark ruling of the nation's Supreme Court on the matter. First, the Apex Court declared that it is unconstitutional for state governors to hold on to funds meant for local government administrations. The Supreme Court also barred governors from dissolving democratically elected local government councils in the country, saying it would amount to a breach of the 1999 Constitution. Now, this is something governors in the country have always done with reckless abandon, if you like. So the court now has declared that the appointment of local government caretaker committee is also unconstitutional. In the lead judgment of the court read by Justice Emmanuel Agim, the Apex Court observed that the refusal of state government on financial autonomy now for local governments has gone on for over 2 decades. So it ordered that funds meant for local governments must be paid directly from the federation account to the local governments rather than through the states, since that process has so far not worked. The court also held that no House of Assembly of any state has the power to make laws that could in any manner interfere with monies meant for the local governments. Now, the Apex Court dismissed the preliminary objections filed by state governors. Don't forget, the federal government, through the Attorney General of the Federation, Lateef Fagbemi, had actually sued the 36 governors over full autonomy for local governments in the country. So at the moment, the federal government, we're talking about revenue allocation now, at the moment, the federal government gets 52.68% and states get 26.72%. That's in terms of revenue allocation. In comparison, local governments get 20.60% of the country's monthly revenue allocated by the Revenue Mobilization, Allocation and Fiscal Commission, which operates under the presidency and disbursed by the Federation Allocation Committee. That's FAC. Now, before this landmark ruling, local government funds were paid into a joint account operated by state governments and local governments in their domains, with state governors having more or less unilateral control over the funds and how they are utilized. But going forward, that would no longer happen. Let's discuss this further. I'm being joined on the program by 2 legal practitioners now. Fred Nzako is, of course, a lawyer, and also have Gabriel Ehigato, who is a lawyer as well. Gentlemen, thank you very much for coming on the program. Fred, let me begin with you. How significant is this ruling? And did it come to you as a surprise at all?
The ruling is very significant. But it is not the first time Supreme Court. So that is more or less a reinforcement of earlier ruling at the Supreme Court. The call that.
Fred, we have a problem with your audio. I'm going to come back to you. Let me just go over to Gabriel while we try to sort that audio out. Gabriel, give me your take on this ruling.
Well, it's a happy day for Nigerians. It's a happy day for democracy. It's a happy day for everyone that believes in the true governance and social development of this country. I think this afternoon, for once, we should salute the integrity of the Supreme Court. We should salute the scholastic and the erudite judgment given by my Lord, the Honorable Justice Emmanuel Agim of the Supreme Court. And I must say that is a welcome development, because over time, the governors of every state have turned the local government to their own pocket pin, or whatever you may call it. They've degraded the local government. They have relegated the local government to the most distant background. That, as we speak, the local government have no say when it comes to governance of any state. The local government wishes to be the third tier of government, the third level of government. You know, the government that is closer and the most closest to the people have been relegated over time. They have been oppressed over time. They have become the private empire of the governors of every state. So this afternoon, the Nigerians are happy. There are jubilation in the street. People, lovers of democracy, are happy with the Supreme Court judgment that local government is not that tied to the apron of the governors of the state. That local government is the government that exists on its own, as such should control the finance that comes to it for the development of the people. We are very happy. We are very happy as lawyer. I'm happy as an activist that this judgment have come to see the light of the day. And of course, it has also drawn the bottom line. For over time, people have been saying, what exactly is the efficacy and the effectiveness of local government in every Nigeria? So as we speak today, sir, the 774 local government of Nigeria have had a life and they have breathed, and we are very happy over it.
So thank God we have you back, Fred. So go on. You were trying to explain something. Just go on.
Yes, I was trying to say that the judgment of the Supreme Court of today, as landmark as it is a reinforcement of 2 or 3 previous judgments given by the same Supreme Court on issues around the local government autonomy and whether or not the state governor or the House of Assembly of any state has the authority to dissolve elected local government council. The Supreme Court had said that copiously in a matter of Giang versus Plateau State and another matter concerning the local government system in Cross River State in 2017. So this one is a reinforcement of that, but the peculiarity of this particular judgment is that it has given full financial autonomy as enshrined in the Constitution. But it is not yet uhuru because there are so many bottlenecks along the line which need to be cleared. For example, the issue of the state and local government joint account, which is clearly stated in section 162, subsection 5 and subsection 6 of the Constitution. If that is not cleared, then the autonomy given by the Supreme Court will be a paper autonomy that will not be practicable.
But let me quickly come in there, because I think the judge actually alluded to it. Remember, Justice Agim, when he was giving the judgment, actually said, look, it is true that the Constitution provides that local government funds should be paid either directly to the local governments or through the states. But then he said, look, this law has to be interpreted progressively, and that since paying through the states, that's by means of the joint account now, has not worked, so the court ruled that the money should be paid directly to the local government. So I would suppose that probably took care of this joint local government account that you're referring to.
Yes, it does, but if it is made as an obiter, then that will be difficult. I expected that the justice of the Supreme Court will make a very clear and definitive statement in that regard, so that it will shape up the provisions of Section 162.
From what I heard, what I heard and read, I mean, I would suppose it was a definitive pronouncement now from the Supreme Court. But I'll come back to you. Let me find out what Gabriel thinks.
Well, our laws are very clear, and one of the major duty of the Supreme Court, it being supreme, is the interpretation of our laws, and the Supreme Court have done so well. I do not think when you take a look at the judgment, the statement, the interpretations, we are very clear. But trust me, this Nigeria, where we have politicians who do not give a good regard to our laws and our judgments, I won't be surprised tomorrow any public officer comes up and challenge the interpretation of even the judgment that was given to by laws in the Supreme Court. But be that as it may, the judgment has been given. The message is clear, and there's no ambiguity at all. There's so much clarity in the way and manner that the judgment was given. And it is supreme because the Supreme Court is not supreme because it's infallible. It is infallible because it is supreme. And that is the law. It's a welcome development.
And let me come back to you, Fred. Look, at the end of the day, the implementation here would rest with the federal government. So now the federal government, would you say now that the federal government would stand on a firm ground in actually making payments directly to the local government, now, rather than through the state governments? Remember, the former president tried to do it, not using the court, but he did not succeed. So, but now with this judgment, would you say the federal government is now armed to ensure that, look, funds go directly to the local governments?
Well, like I agree that the implementation rests on the federal government, especially in terms of release of the funds from Federation Accounts Allocation Committee, that the fund will now go directly to the state government. But we need to call out and bring out some of the booby traps that are still on the way to full autonomy of the local government. And one of the major one is the issue of election of local government officials, the chairman and the councillors of the local government. Section 197, subsection 1B of our 1999 Constitution as amended, made provision for the creation of state independent electoral commission. And if you go to section 7 of the Constitution, which talks about the creation of the local government and a guarantee of to ensure that the state government guarantee the existence, the structure, and the performance of local government system, you find out that a combination of all these sections that have to do with local government leaves a lot of responsibilities in the hand of the state houses of assembly and the state governments. So National Assembly has to look deep into this and touch some of these sections so that the governors will not see escape route to still control the local government system. Because if the local government election will still be conducted by state independent electoral commission appointed by the governors, financed by the governors, managed by the governors, I can tell you that it will be a quasi-autonomy because the acolytes of the governors and the hangers-on, in fact, the election will be more or less a selection of the people of the local government system.
Which is, of course, which is what we have seen all this while anyway. And Gabriel, that's a very strong point that Fred raised there. Because the question is, if you do not have political autonomy for these local governments, if governors still control local government elections and they go ahead to just, appoint, because basically, you look at local government elections we hold in this country, they are not elections, they are basically selections and everything at the whims of the governor. So how do you think this financial autonomy would change anything at all if there's no political autonomy? If the powers to conduct local government elections, for instance, is not taken away from the states and probably given to INEC?
Well, it will be good as if nothing nothing has changed. Just the way my colleague said, the financial autonomy should be in pari passu with the political autonomy. If not, the local government is going to have their own money by the financial autonomy, and there will still be a political undertone, which will not make the administration see go smoothly. It will be as good as the judgment is useless. But when you compare the financial autonomy with the political autonomy, I'm sure you are going to have a very good day in running the successful administration of local government. And of course, the INEC for the national level should be the one to conduct the local government election, because the local government election we have over time is just the primary exercise of the governor of the state, because it doesn't really make sense that the people who come out to vote their conscience and vote the candidate they want, and one person who, simply because you are privileged to be a political holder of the office of a governor, will come over and say they dissolve and sack an existing government that was collectively elected by the electorate.
How important is it that part of the ruling says, look, that the Constitution does not provide for local government caretaker chairmen, so that they must be democratically elected. And so for those who are not democratically elected, they're definitely not going to get funds. They're definitely not going to get these funds. How important is that? Yes, it is true. Local government elections are nothing to write home about. But then, the whole idea of appointing local government caretaker committee chairman, as every governor would do when they come into office, obviously is dead now.
Yes, it is dead. And the Constitution does not provide for this thing called caretaker. What the Constitution envisages is elected council, elected local government chairman and councillors. And for some tenure of 3 years, re-electable for another 3 years, and that will be all. But what the governors do is they don't conduct the election because the responsibility of conducting the election is in the hands of the state government through the State Independent Electoral Commission. If the governors don't fund the commission, if they don't even constitute the commission, then there will be no election. And because there must be no vacuum in local government administration, they now go to appoint the caretaker committee, which this is not the first time the Supreme Court is frowning at such practice. In some other judgments in the past by the Supreme Court, as I earlier mentioned, the Supreme Court has said very copiously that it is a breach of the Constitution by the adoption of caretaker committee to run the local government system. So it is a very good thing that the Supreme Court has today reinforced those earlier judgments and has today reinforced the provision of the Constitution. But like you said, the political autonomy is very important because that is what will drive the financial autonomy. And that is what will bring credible people to come and run local government system. Unlike what you see today, it's as if it is the chaffs and the dropouts that are picked by the governors to be manning the local government systems, unlike in the past, where even the election to the council was hotly contested, and you will see people of integrity and people of knowledge coming to run the local government system. We want to see a rebound of such practice so that our local government system, which is the closest to the people, will be up and running and will be credibly run by people with knowledge and responsibility.
Okay, let's take a short break here. When we come back, I want to get your views on this issue of local council development areas that most of these governors have gone ahead to create. So what happens to them? That's what we'll be talking about next. So we'll take a short break and we'll be right back. Welcome back. And if you've just joined us, we're discussing the outcome, the fallout of the Supreme Court ruling on local government autonomy. And with me on the program are two lawyers, Fred Nzako and Gabriel Ehigato. Let me come back to you, Fred. So now the Supreme Court says local government funds should go to local government authorities, directly to them. But you know that some of these governors have created local council development areas that are not recognized in the Constitution. They've not been ratified, so to speak. You take the case of Lagos State. Under the Constitution, what is recognized are just 20 local government areas and not the 57 that you have in Lagos. So since these monies will be going to the local government areas, they obviously would be going to the 20 and not the 57. And we know that what the governors did in the past is that because the money was coming directly to them, then they were just resharing and, deciding what to give to, especially to the local council development areas. So what happens in this case?
What will happen is that the states will have two options because the 774 local government areas, local government councils recognized by the Constitution are the ones that will be funded from the federation account. The others created by the governors that they call local council development authorities will not get any funding from federation account. And now that the Supreme Court has cancelled the state local government joint account, and when that implementation becomes full blast and successful, then the local council development areas, since they will not be funded by the federation account allocation, and the governments will have only an option of either funding them through the internally generated revenues of the state, or outrightly obliterate those councils, in which case delete those councils and then allow the recognized local government areas to run their affairs the way and manner it has been contemplated by the Constitution. A third leg to it will be to subsume the local council development areas under the local government councils, in which case, whoever that is the chairman of the local government council will be also the supervising the local council development authorities. It will no longer be a matter for the state government to determine and to allot funds the way and manner they deem fit. That is the scenario that they will face going forward.
Gabriel, could we have a situation, because you know, look, this is politics, and you can't just put this beyond the governors. Do you think, even if they don't do it openly, that we could have a situation where some of these governors would probably mandate these local government chairmen now, the ones that are recognized, to make contributions, so to speak, to the state joint accounts? And so you would have a situation where these monies that are coming directly to the local government chairman would indirectly find their way now to still find their way to the joint account, where some of these governors may want to use the money to fund these local council development areas.
Ordinarily, the local government councils area are not recognized by the law. Even to date, they are not. Except the local government council, which is the 774. In some situation, I think the government or the governor have no other option than to fund those local government, council area they created by themselves. Either to fund it by themselves from the state coffer, or they have to consume it under the politically constitutionally recognized local government. But to answer your question, I think if that happens, then that means that our local government fund will be selected, in order to bring in other non-existent activities that is not recognized by the Constitution. The local government council development areas are not recognized by the Constitution, and as such, should not be catered for, should not be given the money, that is made to the local government, the recognized local government areas. Because that money is made for local government areas to run the administration and the governance of that local government. So for us, I think we should leave that political edict, so to speak. Let's leave it for the governors to handle, because they created those local government by themselves, especially in a place like Lagos, where we have extra local government areas, the way they are created by the then governor Bola Ahmed Tinubu. So the local government that is recognized by the Constitution will only be funded by the federal government directly. So those that are not recognized, I think, will be catered for by the state governors who created them.
Fred, this is certainly going to be a very tough nut to crack.
A very tough nut, because some of the reasons why the governors created the local council development areas is not because they wanted, it's not only because they wanted the government to get closest to the people, but they also wanted to create jobs for the boys, because that is how they now mortgage the electorate during elections. And by the time they create a lot of jobs for the boys, they now use that to control the people at the times of election. So it is serving them some political purposes, and now try to pretend as if it is also serving developmental purposes. The issue of developmental purposes we are yet to see, but it is very obvious that it is having the governor's political purposes. And they will, I guess that they will try to subvert this judgment of the Supreme Court and find a way to circumvent it. But it is the duty of Nigerians not to allow such circumvention, because we have been crying aloud that the local government authority should be given the autonomy that they deserve.
Honestly, I'm still trying to wrap my head around this. It's a big headache, and Gabriel said we should leave it to the governors, that they created the headache, they should deal with it. Honestly, it's going to be tough, because you take Lagos, for instance, where about 37 local council development areas were created. You have 37 local council development chairmen, you have deputy chairmen, you have workers in all these local council development areas. And I know of other states too where the same thing has happened, in Kano, almost everywhere. And I'm just wondering, this is certainly going to be tough. And do you think that probably what should happen is that the National Assembly should hasten the process so that the entire process for the creation of this local creation of these new local governments now is consummated and concluded, so that they become recognized?
It is not only the National Assembly that is supposed to work in that regard. I recall that the creation of extra local government was that from the state houses of assembly, and then and snowballed to the National Assembly for legislative concurrence before it is ratified by the president as a constitutional amendment. That was what happened to that of the 7 LCDAs created by Bola Ahmed Tinubu then, when the Supreme Court said that such creation was inconclusive, inchoate in nature, and technically non-recognized by law. And I can tell you that it will still suffer the same fate, because National Assembly will not likely want to give concurrence to that, on account of the fact that anyone recognized by the Constitution, the Federation account will have to fund it the same way it is funding the 774 already recognized. So you now have a clear case of challenges before National Assembly, because many governors will want to create as many local government development areas as possible, hoping to get accentuation by the National Assembly. So
and the question is, where do you get the funding to even fund them?
That is the challenge. Where do you get the funding to fund all those ones? And that is why, after all said and done, we will have to stick to the 774 that has already been created and recognized by the Constitution.
Let me get a final word from you, Gabriel, on this issue.
Well, for me, the record development, the Supreme Court have given off, in fact, they've allowed the local government break, and is a record development. But this we have a problem. It's not just enough to give a landslide judgment. I think the enforceability of the judgment, we should put the machinery should be set in place to also do that. The political autonomy should be married with the financial autonomy, so that local government can come back to their feet.
Gentlemen, thank you very much for coming on the program, and thank you for your incisive contributions. Thanks a lot. All right, that's how much you can take on the program. We'll see you again next time. Bye-bye.